Go Henshaw here again, your constitutional kook from San Francisco. And this is part 2 of my video on artificial intelligence and why we should be using this in our court system, quote unquote. And I've been through some things myself. You go through, and for example, I have a multi-million-dollar federal default judgment in an eviction case. And I did that because I knew what to do, when to do it, and how to do it in the quote unquote trial court, aka administrative tribunal. And the only time I saw the bastard attorney for the other side, I handed him my 48-page motion plus exhibits. And I said, "Here you go, son of a bitch. You can't answer 2 paragraphs." He didn't even attempt to do it. And if you're the plaintiff, you have the sworn duty of burden of proof on jurisdiction and venue of the trial court. There was no way in hell to do it, since it wasn't a trial court, it was an administrative tribunal, like they all are today. So I file in the federal court and go after them, and I carefully do it in the federal circuit court. That's an Article 3 judicial court, which, as you'll learn from getting my modestly priced constitutional defense document packets, is required to be there. The Constitution mandates it. The Supreme Court has ruled that way, and the greatest expert ever on the Constitution, Justice Joseph Story, back on the court for 33 years in the early to mid 19th century, said exactly that. Congress has to create judicial courts. If they don't do that, then every law in the book gets thrown out on its face as a bill of attainder, taking life, liberty, or property without judicial process. And that goes back to the Magna Carta 800 years ago. We have the right to trial by jury according to the course of the common law, which is available to even inhabitants of territories, for crying out loud. That's Article 2 of the Northwest Ordinance of 1787, as reenacted by the first Congress, and yet nowhere in sight today in what purport to be sovereign independent states admitted into this union. What the hell happened here? So returning to my federal case, I get it filed and served, and the bastard attorney doesn't answer this one either. Now, to be sure, I have burden of proof here in the federal court, but no problem, because he didn't pick up his burden in the state court, and I proved my case. So this is a default judgment. Even if he shows up, he's going to get a motion to strike because he didn't answer when he had the duty to do it. So all that gets done. And the next thing I know, the case gets dismissed by a federal magistrate on Rooker-Feldman grounds. We'll learn more about that in an upcoming video. But basically what that says is if you can't pay the filing fee, your pleadings are specious, frivolous, and without merit. But I demanded on the record for them to define dollars so I would know how to pay the fee. That didn't happen. Can't go in there with Federal Reserve notes, aka evidences of debt. Article 1, Section 10, U.S. Constitution, no state shall make anything but gold or silver coin a tender in payment of debt. So it gets thrown out by the magistrate, and I fire off a letter to the presiding judge demanding the case get back on the docket. Within about a week or 10 days, it was, only to be dismissed in the same way by an Article 3 federal judge. There's none of them in office either. We'll talk more about that on another video. But that happens. And then I've been communicating with the court ever since. I can't get it back on the docket. But think about it, people. And a lot of you are familiar with this. You never get heard in the trial court, which is in a court. It's an administrative tribunal. And if you go to federal court, you never get heard there either. That's not even due process. If we don't know if we're wrong, let alone why, how do we instruct our representatives, quote unquote, to make changes or nominate and elect those who will? How's that again about elections? There are none. And you'll learn that too. Send me an email, unincourt@gmail.com, and we get past all this BS and get to the real issues. So that said, both of these appointees, happen to be Biden appointees, for what that may be worth. And the quote unquote Article 3 judge was the lowest on the seniority totem pole and got assigned this case because no one else wanted to go near it because they knew. But this Brooker BS, by the way, you can't pay the filing fee, speeches, frivolous without merit. Well, the problem is if Brooker were to apply, that's a 100-year-old case, by the way, coming up this December, and it doesn't apply, and the justices on the court know it now. I may be the one to break Rooker-Feldman, and I hope I am. But the big deal about that is that for that to even apply, the Supreme Court ruled that the state court had subject matter jurisdiction in personam and in subject matter. There was a full and fair hearing on the motion in the trial court, and the order was responsive to the pleadings. None of that ever happens, and none of it needs to in their administrative tribunals. They own you. Get over it. But the problem with that is now I get to the U.S. Supreme Court and make these arguments with Rooker-Feldman, and I would love to be the one to take this off the books, and that could happen this term. I'll keep you posted about events here and get this settled. And now the default I have is going to double because the default I got was for the act of treason that occurred when this attorney filed in a court he knew didn't have jurisdiction. But now he's paying for multiple acts of treason I can prove occurred in the federal court. Enough is enough already. And this is what you want to learn. Send me an email, uwincourt@gmail.com. I'll get you up to speed on my modestly priced constitutional defense document packets, and you can learn to follow what I do and be able to do this for yourself, your family, and your posterity. That said, remember to subscribe, like the videos, tell your friends, get the word out. Thank you.